Patricia Johnson.
You swear or affirm testimony about in this case, the truth, the whole truth, nothing but the truth,
Ms. Johnson, how are you this morning?
I'm fine.
State your name.
Patricia Johnson, Patricia Wall Johnson.
And you're a county clerk?
Yes, I am.
And you're a defendant in this case?
Yes, I am.
Okay. And you know what this is about?
Yes, I do.
If the judge in this case does not issue an order, perhaps stopping this election or restraining order, are you going to have an election?
If the election commission says I will, I have to.
Okay. And that is your function as county clerk?
Just do whatever they tell me to do. Yes.
All right. That's all.
no questions. Your Honor, is she free to leave?
No, we're not going to recall it.
Claims of arrest, I would believe by motion to dismiss. That was failed to elicit any new facts to further buttress the complaint. And if I may, Your Honor, Your Honor, conspiracy is not a requirement for the court to issue written mandates. However, in election contests, there are requirements specified by the statute. Those particular statutes I argued earlier, and I won't rehash them again, but to say that Mr. Gibson agrees that the facts of his complaint don't fit either the pre-election contest or the post-election contest. Therefore, Your Honor, the complaint alleges no facts, and counsel acknowledges that their complaint is deficient, and they're not entitled to written mandates, which would only be proper in the instance where the plaintiff had filed a pre-election contest. I also renewed the Jefferson County defendant's objection for the motion to dismiss as it relates to failure to state facts sufficient and for the court to grant relief under Rule 8A and Rule 12B6. And Mr. Gibson solicited some testimony, but the testimony today that he solicited was that Mayor Hollingsworth was sworn, that Mayor Hollingsworth signed a certificate, an oath. That's the only additional evidence. The complaint alleges conspiracy. And while it's not a requirement, that's what they plead, not the defendants. That's the pleading that's before the court today. And based on pleadings that are properly before the court today, the plaintiffs failed to state any of the essential elements to a conspiracy. They failed to establish that by proof as well, here today in this hearing. The plaintiff has also failed to challenge the eligibility of Mr. Reeves as a candidate. And in that case, Your Honor, we don't believe that she would be entitled to the issuance of a written mandate on the facts of this case. Now, I would agree with counsel that election contests are not the only place or not the only instance in which the court can issue a written mandate. And that was not my argument. That's not the argument that I made. Based on the facts that we have before the court today, this is nothing more than an election contest. And there are two causes of action in election contests, which I've stated before. Certainly, Your Honor, we have also, plaintiff has also failed in their case in chief to establish any likelihood of success on the merit. They've also failed to establish that there's irreparable harm. There's the conclusory statement that, yeah, well, I'll be harmed. and nothing further. And it's the same way in the complaint, Your Honor. So we certainly would argue that they are not entitled to any injunctive relief under Rule 65, Your Honor, because they failed state cause of action. The court has properly addressed the issue with the issue of attorney's fees, we believe, and the court can certainly consider that issue further, only to the extent that I just again state that attorney's fees are only proper in certain circumstances, and none of those are present in this particular case. Again, in their case in chief, did not join Mr. Custom as an indispensable and necessary party. And, Your Honor, we believe that that is also fatal, or that the court should join him should the court decline to grant our motion to dismiss. Your Honor, I would say this in closing. Again, mandamus relief is not a remedy for anything other than election contest, or anything other than pre-election contest, not a post-election contest. And the plaintiff does in fact have other remedies that law. Those being the post-election contest and also the prospect of defeat. Thank you.
Now, let me rephrase it. I did not simply extend attorney's fees. I'm already ruling that. No attorney's fees, extend possibly the case of
Please state your name.
Election Commissioner.
My name is Theodis Calvin Davis. My nickname is Ted Davis.
And Mr. Davis, do you currently hold a position with the Jefferson County Election Commission?
Yes, I do.
And what is that position?
I serve as chairman of the Jefferson County Election Commission.
And how did you become chairman of the Jefferson County Election Commission?
I believe I was elected February 20th, 2013 by the majority of the election commissioners.
Okay. How did you come to be elected to or nominated for the Jefferson County Board of Election Commissioners?
I serve as chairperson of the Jefferson County Democratic Central Committee, and in doing so, that position, the bylaws requires us to serve as a commissioner, and the commission then elects the chairperson, and I was elected as chairperson of the Jefferson County Election Commission.
Okay. And you were duly elected as chairperson?
Yes, I was.
So as the chairperson of the Democratic Central Committee, were you duly elected to that also?
Yes, I was.
And what's the process for being elected to that?
There is a meeting of an election held rather, of the Jefferson County Democratic Central Committee, and as a result of that meeting, I think it was 50 people voting. I received 45 out of 50 votes.
Okay. So now, Mr. Davis, I want to get to the issue of the preferential primary for May this year. How did the whole issue of the election come about?
The preferential primary, if you talked about initially, the preferential primary came about through the fact that the Pine Bluff City Council passed a resolution, I believe it's 3551, to hold a municipal primary, and I think that was that was passed, I believe, December 2012, I believe, approximately at that time.
Okay? And as a result of that particular resolution, what happened?
But as a result of passing 3551, then I took a look at the first opportunity to implement 3551, which would be the municipal primary. And then looking at Arkansas State Law 1443-305, it indicated that a city of the first class, population below 50,000, with the mayor, council, form of government, should hold an election on the midterm, which would be, when you calculate and extrapolate back from the legislation, it says that the midterm election should be this year. So therefore, with the primary being implemented by the city council, and the fact that state law says that the city of Pine Bluff met the qualifications of being the city to elect on the midterm, and then a follow-up in January, a follow-up to support the information I had previously relative to state law. A follow-up I read in Citizen Times magazine from the Municipal League, the Arkansas Municipal League, that laid out the year's election process. And in that, specifically, they indicated the same thing that we had gotten previously in state law, which would be that the primary should be held this year. If the city council had passed that legislation, then it would indicate specifically that the primary would be held this year.